Hello everybody, I'm George from Ireland. Welcome back to my English Law channel. So I'm carrying on with co-ownership and looking at the acquisition of equity in homes and seeing what the current law is, especially in the light of Jones and Kernot, the Supreme Court ruling over which Lady Hale of Richmond presided. She was the President of the Supreme Court. She has since taken retirement. So at this ruling, it went over the law and hopefully crystallised Stack and Dowden. And indeed, it affirmed the approach adopted in Oxley and Hiscock. That's a 2004 case. But not all the Supreme Court justices see eye to eye on this. Common intention is vital here. How they can draw inferences or how there can be an imputation, and whether fairness is the core question or not. So there is a lot of fierce debate on this issue. So sometimes judges have arrived at the same conclusion, but by a different line of reasoning. So the key principles were adumbrated by Lady Hale and Lord Walker, and this was said in paragraph 51 of their judgment. The following are principles applicable in cases such as this, where a family home is bought in the joint names of a cohabiting couple who are both responsible for any mortgage but without express declaration for their beneficial interest. 1. The starting point is that equity follows the law, and they are joint tenants both in law and in equity. 2. The presumption can be displaced by showing A, that the parties had a different common intention at the time when they acquired the home. B, or that they later formed the common intention that their respective shares should change. 3. Their common intention is to be deduced objectively from their conduct. The relevant intention of each party is the intention which was reasonably understood by the other party to be manifested by the party's words and conduct, notwithstanding they did not consciously formulate the intention in his own mind, and even acted with some different intention, but he did not communicate that to the other party. Quoting Lord Diplock and Gissing, 1971. Examples of the sort of evidence which might be relevant to drawing such inferences are given in Stack and Dowden. It goes on, but it's worth quoting at some length. 4. In those cases where it's unclear either A, that the parties did not intend joint tenancy at the outset, or B, had changed their original intention, but it is not possible to ascertain by direct evidence or by inference what their actual intention was as to the shares in which they would own the property, the answer is that each is entitled to that share which the court considers fair, having regard to the whole course of dealing between them in relation to the property. That's quoting Lord Justice Chadwick in Oxley and Hiscock, a 2005 case. Anyway, it goes on, Lady Hale's ruling. In our judgment, the whole course of dealing in relation to the property should be given by a broad meaning enabling a similar range of factors to be taken into account as they may be relevant to ascertaining the parties' actual intentions. 5. Each case will turn on its own facts. Financial contributions are relevant, but there are many other factors which may enable the court to decide what shares either intended, as in case 3, or fair, as in case 4. End of quotation. So, in both Stack and Dowden and Jones and Kernot, there was a title that was held in joint legal names. So the question in both cases was limited to quantifying the shares in the property in which both had an interest through their joint legal title. So Lloyds Bank PLC against Rossett 1991 is another key case. So this one is much trickier. They were not in joint legal names. So Mrs. Rossett and Mr. Rossett's the other person in the house had to demonstrate that she'd acquired an interest in the house before there could be any quantification, and whether she had an interest in the house was contentious. The House of Lords found that there not being any express common intention, she could only acquire an interest if she had made a direct financial contribution to buying the house or paying the mortgage. So after Stack and Dowden, there has been much contending about whether or not the House of Lords reasoning in that case is applicable in a case about acquisition. And some scholars of jurisprudence have said we need a much less extensive approach, such as in Rossett. And is that still applicable or not? If the home is not in joint legal names, despite what Baroness Hale said in Stack and Dowden. And Lord Bridge said that Rossett is now no longer valid. So only a few weeks after Stack, there was a case called Abbott and Abbott, 2007. So the Privy Council appeared to apply these cases to, I think it was a case from Barbados, for which the Judicial Committee of the Privy Council, still the Court of Cassation, said that these principles had applicability in a case where legal title was not in joint names. But on that case, acquisition was not in contention. So the legal owner already agreed that his wife had a beneficial interest, and therefore the judgment was only about quantifying the shares of the descendant interest. Sorry, it wasn't Barbados, it was Antigua and Barbuda. So there were no provisions in Antigua and Barbuda to reassign property interests when the party divorced. The family home was only in the name of the husband. So the trial judge said, we're going to split it evenly. But the Court of Appeal threw that out. They said the wife had not satisfied Lord Bridges' test as set out in Rossett. The Court of Appeal found that the wife was only going to get a small share, which represented by what she contributed financially to the mortgage. The Privy Council overturned that and went back to the original judge's award, and so Baroness Hale, she repeated Lord Bridges' approach in Rossett. She repeated the fact that that one is no longer good law. So she said that Stack was applicable here. She took a holistic view of the facts. So looking at it in the round, she says, in modern times, common acquisition is something we can infer when there's any contribution to buying the house, whether direct or indirect. So this is going further than the ratio decidendi in Stack. So it's not just about quantification of shares or establishing them, but it shows that there is a more adaptable approach to acquiring an interest. So Lloyds Bank PLC against Rossett has been largely thrown out. So even though we had Abbott and Abbott, this is the case didn't consider acquisition as such, because the Privy Council decision is persuasive. It's actually not actually binding because it's about Antigua and Barbuda. So some people still say, no, Lloyds Bank and Rossett is the right authority. And legal title, when it's in a single name, despite what Lady Hale said, well, she's wrong. But the Court of Appeal said this is bogus. There was Geary and Rankin 2012. The case was about property held in the name of a single trustee, but the court said that it was Stack rather than Rossett is the case to follow. Furthermore, the decision of O'Kelly and Davies 2004. Well, in that case, the court said there are wider arguments from Stack which can show beneficial interest in land. Notwithstanding that, there seemed to be no binding authority. So, have we really thrown out Lloyds or not? Lloyds and Rossett, I suppose we have. So blatantly, if legal title is the name of just one person, then the non-legal owner has to first of all demonstrate that he or she has acquired an interest, and it then can be quantified under the principles outlined in Stack. So the Court of Appeal therefore said that there's a bipartite test. First of all, the claimant has to demonstrate there was common intention, that he or she should acquire an interest, and second of all, a common intention about how much that interest would be. So common interest about acquiring a house can be inferred from words, other behaviour, inferences. The Court of Appeal is prepared to allow the size of the share to be imputed even if there are no words written or spoken which can be attested to. So inferences could be sufficient. Could be, not always. All right. So isn't it odd that this new approach after Abbott and Abbott 2007 means cases such as Oxley and Hiscock and Stack and Jones about Stack and Dowden, Jones and Kernot, the equitable interest in property is divided in shares that equated to the parties' financial contributions. What is different in these last two cases, it was the female claimants who were defendants who were the main breadwinners and not the male partners. And previously this sort of line of reasoning was thought to favour women over men because men usually earn more. So the narrow approach in Lloyds Bank and Rossett seems to be old hat. And Stack is largely dealing with legitimate expectations of those who made contributions which were not pecuniary in nature. It used to be mostly women looking after children and being the housewife, but they could seldom prove a direct financial contribution, and they didn't usually have an express arrangement. So the price paid is high because Baroness Hale's broad approach has made things very uncertain. So each case has to be judged on the relevant facts, and lots going to be left up to the temperament of the particular judge. So it's a bit of a lottery, therefore. So it's tricky for solicitors to say what the law is on this one, because it seems to be in flux. Anyway, So the Law Commissioner said we got to have some reform on this. So we have clarity on this issue. Ooh, okay, so just got to turn the volume down on my computer in case something suddenly switches on. Anyway, it's not just the courts which are flummoxed by this. So there's a cohabitation paper put forward by the Law Commission in 2007 saying, relationships are never going to break down, and the law has to get its act together on this issue, and we've got to know what's what. Cohabiting is much more common than it used to be. It's not that we know what the situation is clearly when there's marriage, because a lot of people are not getting married. They're deserting it in droves. So the current law doesn't seem to be designed for 21st century mores. So some of these outcomes might be unjust. So they didn't suggest that cohabitees should have the same rights as people who are actually married. The Law Commission says when a unmarried couple have lived together for a certain number of years, however many years has been set out yet, or had a child, and have not expressly agreed that new scheme should apply to them, the new principles should apply to them, allocating the property in a particular way in case the relationship comes to an end. And that would make it needful for the claimant to demonstrate that he or she has suffered some economic loss by making contributions. So the court would then have the scope to grant whatever is apposite financial relief, especially in view of children. But they have that anyway with regards to children, child support. So these suggestions are limited, and they wouldn't apply if the cohabitant is not a couple, they're simply friends, or as a third party there. So that's the situation at the moment. If that sounds nebulous, well, it is.